Welcome again to the Melling Law YouTube channel, where we discuss different estate planning, probate, and asset protection topics. This week's video is all about estate planning for minor children. We will explain some different tools you can use to make sure that your children are cared for if something happens to you. Most people don't realize this, but if you don't have anything in place and something happens to you, your children will have their court-appointed guardian manage their finances until they turn 18, at which point they will receive anything you leave to them outright. I don't know about you, but I would not have trusted my 18-year-old self with any substantial amount of money, so it's important to make sure your children are not put in the same situation. We're going to discuss 4 major factors that you need to consider when planning for the needs of your minor children. Those include someone to take care of their daily needs if something happens to you, someone to manage their finances while they are minors, planning for unexpected special needs or emergencies, and helping your children transition into adulthood responsibly. First and foremost, a guardian for your children is something that you want some say in. No matter what, a court will decide where your minor children will go if something happens to you. However, if you leave behind a recommendation in writing, a court will usually go with that recommendation unless the judge has very good reason not to do so. Obviously, leaving your nomination in writing is especially important if your first choice is not a close relative. Some factors to consider in choosing who to nominate include where you would like your children to live, who you want them to live with, and whether you want that person to be responsible for their health care decisions. These concerns can be especially tricky in a blended family situation, so I strongly suggest you seek expert advice if that applies to you. Finally, you need to consider whether you want the guardian of your children to also manage their finances. If not, there are ways to split the role of guardian and conservator, or the legal word for financial guardian. If you die while your children are minors, anything left to them through a will or as insurance or retirement beneficiaries will be managed by someone else. The same thing goes for gifts left to minor grandchildren. By default, that person will be their guardian, but you can change that through a little estate planning. Some important factors to consider for the finances of minor children include who you want to serve as conservator, what kinds of things you want the money to be used for, and when you want them to receive any remaining inheritance. By default, your children will receive the remainder of anything you leave behind for them at age 18. If you want to change that, then one simple way is to make sure that anything left to them goes through a UTMA account. UTMA simply means Uniform Transfers to Minors Act, but it's a way to delay the distribution of those remaining funds until they turn 21. However, most people still think that 21 is too young, so you can delay that distribution through trusts or other financial instruments as long as you want, and ensure the distribution is according to your terms. We'll talk more about those in a minute. One thing that people sometimes forget about while planning for minor children is that you can't predict the future. You never know if your child will later be diagnosed with a debilitating illness or have an accident that qualifies them for Social Security, disability insurance, or other need-based benefits. Careful planning can help ensure that your children will qualify for those benefits while retaining a supplemental source of income from your estate. Another unforeseen problem that may arise is an emergency situation where your child will need funds for medical costs or some other unforeseen emergency. If your plan does not allow for any flexibility, then your child may not be able to access those funds when truly needed. One phrase commonly used is to provide for health, education, maintenance, and support. Those words cover many of those unforeseen circumstances and sometimes will provide preferential tax treatment as well. Finally, you know that your children will not always remain minors. When they grow up, you will want to help them become productive citizens. That can be tricky if you're gone, since you can't predict the future or their future needs. However, some considerations apply in most circumstances. First, you will want to determine who you would like to manage any remaining inheritance funds. Many people think of a family member, but depending on the family dynamic, these arrangements can ruin family relationships. Some institutions or private individuals will manage trust funds for a fee, usually 1 to 2% of the funds annually. I suggest you discuss these options with an estate planning professional to determine the best fit for your situation. Another consideration is when you want the funds to be distributed. Do you think your children will be responsible to manage their own finances at age 25, 30, 40? It's a judgment call, but I rarely recommend distribution past the age of 30. One option is to set a maximum age for distribution, but provide incentives for an early distribution, such as completing a college degree or participating in meaningful public service. Once again, that language, health, education, maintenance, and support can provide favorable tax treatment as well as allow flexibility for the trustee to distribute money when needed. Finally, we get into a small tax issue. If the trust earns money on its investments in a given year and that money is not paid out to the trust beneficiaries, then the trust is going to have some income subject to taxation. Those tax rates can be steep, so many trusts have a clause allowing the trustee to distribute the annual trust income in full as a minimum. However, you may not want your child to have that money if it will be wasted or if you want to provide work incentives. If that is the case, you may consider allowing the trustee to donate any undistributed trust income to a charity. You'll want to check with a tax professional, depending on changes in the law or in your state, but generally people will prefer giving money to a charity instead of the government. By way of review, check out this chart. As you can see, only your guardianship designation will have any control over the daily care and medical decisions for your minor children. That designation can be in a will or in a separate document. As far as your child's finances are concerned, a trust is a superior option to anything else because you have the added benefit of determining when they receive any remaining funds, under what terms those funds are distributed, and the ability to help your children responsibly transition to adulthood. You can set up a trust during your lifetime or provide for its formation during the probate of your estate through a testamentary trust or trust created by will. Either way, this is something you should handle through an estate planning professional. So, what steps can you take now? First and foremost, talk to those whom you would nominate as your child's guardian. Second, talk to the people who you would like to manage your children's finances. And finally, put your decisions in writing and consult with a professional to ensure those wishes have a legal and binding effect. Thank you for joining us today. If you have any suggestions for future topics, please comment below and subscribe for more updates. If you have any questions or would like to make sure your children are cared for, you can call us anytime at 435-572-0807 or contact us via email at office@mellinglaw.com.